you turn it up, the volume?
Son of a bitch, they thought me had passed. Should have never walked into that fucking house.
I can't make out what he said in the second sentence he said. Can you play it again, or can you?
Go ahead, Love.
I don't know if I just can't hear it.
Judge, we agree as to what the second sentence was. Do you want me to state it?
Whoever wants to state it. Officer, if you want the officer to state it, if he knows.
Well, I confer with the prosecutor. We'll stipulate to the following, that the second sentence is, I should have never walked into that fucking house.
I've heard that, and there was a sentence before that.
Oh, the sentence before that is, son of a bitch, they caught me that fast.
Yes, I agree to that.
All right, are there any other questions for Sergeant Lawrence?
I do not have any.
I have a problem, Judge. Sergeant, you say you downloaded this entire tape. You watched it as it was being downloaded, correct?
Yeah, correct.
You got to speak up just a little bit.
Yes, sir.
Okay. And earlier on in that tape, my client is asking, what am I being charged with? As he's locked, handcuffed behind his back, and he's in the back of the car. Isn't that correct?
I don't know.
You didn't see that?
I might have saw it, but I didn't memorize everything he said from when he left the scene.
To that effect, didn't he?
I don't know. You'd have to play it for me.
We may have to play it. Okay. He's banging his head against the back sill of his...
Wait. So, I'm direct. We didn't talk about this.
Well, this all goes to the video, Judge. This is things that I've just seen on this video.
Well, I haven't seen that portion of the video.
Well, we're going to play it. I was hoping...
Wait. No, the cross is only going to be limited to the direct exam. The direct exam of this officer was limited because you wanted to look at the video. Okay, it doesn't expand now your cross to the entire video that's not been seen by the court or testified to by this officer. It's limited to what he testified to and what we just saw in that video. If you want her to, if you're going to ask additional questions, it's got to be limited to the direct and to what we just saw.
Well, Judge, the prosecutor went into statements made in the back of the car. I wanted to see the video because under the best evidence rule, rather than getting a scenario from this sergeant, we were able to actually see it ourselves. What I'm talking about is exactly what the prosecutor was talking about. Statements made by my client in the back of the scout car. That's what we're talking about. I'm not getting into anything beyond that, but only statements made by my client in the back of the car.
Do you have a response?
There were, because counsel wanted to have the video played, as the court is well aware, we took a recess, we went in an office and watched various segments of the video. There were four separate...
The video is an entire clip of from when he gets in the car to the apartment to...
There is not. There are four separate clips. And then we agreed that this clip was the clip that was going to be played. This is the clip that I wanted to question the officer about. So now what counsel is going into, this is the first time I've heard that counsel wants to talk about every single statement that his client made.
I'm not going to allow it.
Very well. You see nothing in this clip where my client says he did any crime, correct? He doesn't say I killed somebody, I murdered somebody. He never says that, does he?
No, he just says we caught him too fast.
Okay, all right. And you don't know what he's talking about because you can't read someone's mind, correct?
That's correct.
Nothing further.
Anything else?
No, Your Honor.
Thank you, Sergeant Lauren.
Thank you.
Call your next witness.
The people have no further witnesses, and the people rest at this time.
We have no witnesses, Judge.
Thank you. Motion?
Your Honor, at this time, the people would make a motion to bind over as charged. The defendant obviously clearly the body of the deceased was found in the home, dismembered.
Wait, let me interrupt you. So you stipulated at the beginning to the identification of the body and what the testimony of the medical examiner would have been.
Yes.
You've admitted People's one, which was the report of the medical examiner. I don't have it.
Okay, I'm sorry, can I give it to you?
Yes. And then you also had marked as People's 2 the video.
And as far as I was concerned, that was admitted without objection, and it's of course also admissible under the hearsay.
I just wanted to make sure that it's clear that it's been admitted.
Yes.
That's right, Judge, and that was part of my objection. That's in evidence. That whole video is in evidence.
Well, as far as I'm concerned at this point, only the portion of the video that was viewed by the court and on the court record is in evidence.
Yes, Your Honor.
At this time.
Yes,
Okay,
yes,
now
Your
go
Honor.
ahead and finish.
Okay, I would just say, as to count 2, it's clear from the testimony that the body of the deceased Anna Gorup was in fact dismembered, and the officer testified that there were various red stains about the apartment and on the person of that being the defendant, Dexter Williams, and at one point in his testimony he did indicate to him that was suspected blood. Further, that as to count 1, the defendant indicates, first of all, the defendant by his actions initially not wanting to let the police into the home, not wanting to give his name. Once he is in the vehicle, when he thinks he's alone in the vehicle, once the officers are out of the vehicle, he indicates, "Son of a bitch, they caught me that fast." And going to the medical examiner's report, which the court has, the cause of death is strangulation and blunt force trauma to the head. The people would submit that it is not the cause of death is not something like a singular stab wound or a singular gunshot wound, which is something that can happen quickly and possibly give rise to a murder in the 2nd degree. But it's strangulation and basically beating someone and strangling someone. And as the court is aware that premeditation under the criminal jury instructions does not lay out any specific amount of time, just that the person has an opportunity to think about their actions. And I submit to this court that when you're beating someone and strangling them with your hands or something around their neck, you have time to rethink your actions. And he chose not to. So I would ask that the defendant be bound over as charged.
Any response?
Judge, I would object to a bind over as charged. Clearly, it's a question of fact as to the mutilation, but as to count 1 premeditation, I would submit to the court, first of all, that it was admitted into evidence that my client said to the sergeant that he and the deceased had fought the night before and she had thrown him out. So there's some reference to an argument or a fighting going on between them. And secondly, Judge, I would refer the court to the Hoffmeister case. I'm sure you're aware of it. People v. Hoffmeister at 394 Michigan 155, a 1975 case where the holding was the brutality of a killing does not by itself justify an inference of premeditation and deliberation. but premeditation and deliberation can be inferred from defendant's conduct, judged in the light of the circumstances. Now, I'd also refer the court to People v. Oster, O-S-T-E-R, 67, Michigan Appeals 490, a 1976 case. A magistrate's finding of premeditation or deliberation was clearly erroneous, where there was no evidence of planning or motivation. No inference of premeditation was raised by the fact that a knife was used and that the wounds were inflicted upon vital parts of the body. The fact that the defendant cleaned the knife soon after the stabbing does not suggest that there was a plan or scheme to kill. So I don't think there's anything here to show premeditation, thought involved. We have obviously a terrible situation in terms of the state of the deceased, but Judge, there's not sufficient evidence to show premeditation. If you're going to bind over, Judge, I'd ask you to bind over on murder second degree.
Give me the case, the first case.
Hoffmeister, Judge, Hoffmeister,
The site.
394 Michigan, 155.
155. And Oster was 67 Mishap 490.
67 Mishap, 490.
Do you have any response?
Well, Your Honor, I would just indicate that the defendant's conduct, as stated in Hoffmeister, is something that can be considered in the killing of another person. And in this situation, I think that, again, as I stated, the cause of death being strangulation and blunt force trauma to the head, in and of itself indicates that this was not an instantaneous, quick death. This is not something that was done in the flash of a second in a heat of passion. This was something that took a moment, at least. I would submit to the court, took several moments. But additionally, looking at the totality of the defendant's actions and statements, as it relates to this murder, I believe that it does in fact rise to the level of murder one, premeditation. Thank you.
Thank you.
All rise. You can be seated. Thank you. You can be seated. Thank you. Thank you.
Okay. We're back on the record at 11/20/18 in the matter of the People versus Dexter Williams. Case number before this court is F15117-009. Can you put your appearances on the record once again, please?
Mary Rubio for the People.
Samuel Chirikian for Mr. Williams, Judge.
I just want to, as a matter of housekeeping, go back to the forensic evaluation from December 8th. I want to make sure that we have a stipulation in the record as to competency. I believe we did it at the last hearing. It's not clear in my notes, however.
The People stipulate.
Yes, Judge, we did stipulate already, and we stipulate today.
And that was on January 20th?
I believe so, Judge.
26th. January 26th. Okay, so that's done. And then with regard to the case law that you raised, I've reviewed your cases, and I've reviewed the evidence that's been presented in this hearing, and I believe that the prosecutor has met her burden in this case by establishing that there was an argument, and then through the medical examiner's report with regard to two different specified issues with regard to first strangulation and blunt force trauma, that there is premeditation shown. And so the court will bind over on both charges contained in the complaint and warrant. The arraignment information is on February 26, 2016, and the bond is continued.
Thank you, Judge.
Thank you.
Thank you.